was from Chernobyl. There you go. We're live. Hi, folks. It is officially 9 o'clock according to the clock here in front of me, so I'd like to call the meeting to order, the Special Conflicts of Interest Act Review Committee meeting. Welcome to everyone who's in attendance in the audience and online who's dialing in. I'm MLA for Lac-Saint and Parkland Shane Getson, and also the chair of the committee. I'd like to ask the members that are joining us in the room at the table to introduce themselves, and we'll start that going to my right.
Good morning, folks. I am Martin Long, the MLA for West Yellowhead.
Morning, everyone. My name is Justin Wright. I am the MLA for the charming constituency of Cypress-Medicine.
MLA Garth Rosal, Vermilion, Lloydminster, Wainwright.
Jackie Lovely, Camrose constituency.
Going around the table. Hi, I'm Court Ellingson. I am the MLA for Calgary Foothills. Nothing to do with the County of Foothills or Foothills Hospital.
Good morning. I'm Trafton Koenig with the Parliamentary Council Office.
Good morning. I'm Christina Steenbergen from LAO Communications.
And good morning, I'm Christina Williamson, Research Officer.
Good morning, Nancy Robert, Clerk of Journals and Committees.
Good morning, Aaron Roth, Committee Clerk. Perfect, and we'll go online for those joining us. I feel like mirror on the wall now, so I see MLA Hunter.
Good morning, Mr. Chair. Grant Hunter, MLA for Tabor Warner.
And I see MLA Arkan Paul.
Good morning, Mr. Chair. Brooks Arkan Paul, MLA for Edmonton West Henday.
Perfect, so we have audio and video working. This is a beautiful thing this morning. We're off to the races, folks. Anyone else online? Don't see anyone else. Perfect. I don't have any substitutions for today, unless, actually, not to embarrass a member, because I recently came in sideways myself due to traffic, but we have one more member at the table. We'll allow our gentleman to get settled and then introduce himself. Go ahead, MLA.
Hello, everyone. Sorry for being slightly late. Nathan Depp, MLA Edmonton Southwest.
Perfect. So all aboard who's coming aboard at this point. We're ready to go. A few housekeeping items to address before we turn to business hand. Hansard is actually taking care of us today in a very kind way. They're managing our microphones for us. Committee proceedings are live streamed on the internet and broadcast on Assembly TV. The audio and video stream and the transcripts of the meeting can be accessed via the Legislative Assembly website. Those participating by video conference are encouraged to please turn your camera on while speaking and mute your microphone while not speaking. Members participating virtually who wish to be placed on the speakers lists are asked to email or message the committee clerk, and members in the room are asked to please to signal the chair. And the chair needs to see a signal. I am not a mind reader. There's a lot of things I am, and that's not one of them. Please set your cell phones and other devices to silent during the meeting. And we just had another member join us. MLA Sabir. You just introduce yourself for the record, please, sir.
Yeah, thank you, Chair. Irfan Sabir, MLA, Calgary, Buller-McCall.
Perfect. Thank you, sir. At that point, we're at the lovely time where we can approve the agenda. Are there any changes or additions that are required for the agenda? If not, would someone like to make that first motion of the day to approve the agenda? MLA Roswell? Perfect, away we go. So moved. Any discussion? All in favor? Please say aye. Any opposed? Online, all in favor?
Aye.
Aye.
Motion carried. Approval of minutes. Next, we have the draft minutes of our January 15th, 2024 meeting. Are there any errors or omissions to note? If not, would a member like to make a motion to approve those meeting minutes? MLA Lovely. Any discussion? All in favor?
Aye.
Opposed? Online? All in favor?
Aye.
Aye.
Perfect. Motion carried. We're just ripping right along here, guys. This is great. Review of the Conflicts of Interest Act. So technical briefings. So honorable members, at our last meeting on January 15th, the committee invited the Ministry of Justice Office of the Ethics Commissioner to provide a technical briefing to the Conflicts of Interest Act. So again, folks, there are stakeholders. Here's where it gets a little bit goofy sometimes, is that the officers that are here today are also stakeholders in some of these, but today it's a technical briefing, so they're in that capacity here. So our conversations will be germane to that. Ministry of Justice, at this time, I'd like to turn the floor over to Mr. Mark Arman from the Ministry of Justice. You have up to 20 minutes for your technical briefing and to introduce yourself. And the gentleman to my left has a new timer here. He's just itching to start and try it out. So if there's any technical issues along the line, sir, well, we might have to intervene, but this is like a kid before Christmas today. So with that, gentlemen, start your engines. Thank you. It's over to you, sir.
Understood. I should have brought my stopwatch along, but I'll avoid that. Good morning. Good morning, everyone. Oh, it's right in front of me. That's perfect. Good morning, everyone. As mentioned, my name is Mark Ammon, and I'm here on behalf of Department of Justice. Thank you for the opportunity to provide a technical briefing on the Conflict of Interest Act. I plan to provide an outline of the Act, and the Ethics Commission will also be presenting. So I understand there'll be an opportunity for technical questions after that. The Act was most recently amended last fall, so I'll certainly pay attention to those amendments when I reach them. So broadly speaking, the Act applies to 4 groups: members of the Legislative Assembly, the Executive Council, premiers and ministers' staff, as well as select staff at public agencies. I'll discuss each group in turn, though I'll note that some of the restrictions are applicable to more than one group, and perhaps in the interest of time, I'll kind of identify that. Section 2, this is Part 2, Section 2 to 10, set out the member obligations of MLAs. Broadly speaking, members cannot take part in a decision if it would further their private interest of the member themselves, their minor or adult child, or a person directly associated with the member. Now, the meaning of directly associated is in the interpretation section itself. It includes a spouse or adult interdependent partner, a for-profit corporation, a private corporation in which the member owns shares, and a partnership where either the member or the corporation directly associated with the member is a partner, or a person of a group of persons or a person acting with the express or implied consent of the member. Where they're involved in a matter in which the member has a private interest, the expectation is that the member will declare that interest and withdraw without voting or participating. Members also breach the Act if they attempt to further their own private interest by using the powers of their office to influence the decision of the Crown, or communicating or using insider information not available to the public in the course of the member's duty. Section 6 prohibits members from being concurrently employed by the Crown Right of Alberta, including provincial agencies, the Crown Right of Canada, and other offices set out in a schedule, which would include, for example, University Board of Governors. Would note, however, that a member does not breach the section if they receive no remuneration aside from reasonable traveling and living expenses associated with that role. Section 7 establishes that members, their spouse, a partner, minor adult child, can't receive a fee, gift, or other benefit that's connected, directly or indirectly, with the member's office from someone other than the Crown. Now, there are exceptions to this general rule. First, the prohibition doesn't apply to non-monetary gifts or benefits accepted by the member, our spouse, partner, minor child, etc., if the gift is from the member's political party, a constituency association, a charitable organization, or a Canadian government, whether that be federal, provincial, territorial, or municipal. The prohibition against accepting gifts also does not apply where gifts are accepted as an incident of protocol or the social obligations of the member's office. And I'll note here, last fall, Section 7 was amended to enact some different rules. So under this part, members can accept tangible gifts, fees, non-monetary benefits, non-monetary gifts, if the monetary value does not exceed the prescribed amount in the regulation. And pursuant to the members' gifts and benefits regulation, the prescribed amount there is $500 right now. Under the Act, it treats tickets and invitations to events differently. So where the benefit is tickets or an invitation to an event or fee waiver associated with a conference, for example, or perhaps reasonable travel costs, a member may accept the invitation provided they follow the rules set out in the member's gifts and benefits regulation. Now, under Section 2 of that regulation, those rules are as follows. You can accept an event attendance valued $250 or less with no further reporting. Where the value is more than $250 but equal to or less than $1,000, the member would need to record key details associated with that event. Now, in terms of the key details, those are listed in Section 2.5 of that regulation, but they include, for example, a description of the event, the name of the person who provided the benefit, and the circumstances in which the ticket or invitation were given or accepted. So these benefits, as discussed later, will need to be reported in an annual report subject to Section 12. Now, where the value is over $1,000, the MLA would also need to provide these prescribed key details to the Ethics Commissioner within 60 days of accepting the invitation to the event. In addition to this advance notice, of course, these benefits would still need to be reported pursuant to Section 12. When calculating these values, the MLA would need to aggregate all benefits given from the same source in respect of the same event. They would, however, consider benefits accepted on their own behalf separately from benefits accepted on behalf of other individuals. I'd note as well that if the other provisions in Section 7 don't apply, Section 7.3 of the Act does allow the member to apply to the Commissioner in order to request approval to accept or retain a benefit that would not otherwise be allowed. So in those situations, the Commissioner would ultimately decide that and would be able to add conditions or to the approval, or would be able to identify steps to be taken if the approval was not allowed. Section 7.1 deals with non-commercial flights, and as general rule, members are prohibited from taking non-commercial aircraft. But as with gifts, the section is subject to exceptions, such as where the travel is required for the performances of the member's duty, where exceptional circumstances warrant the travel, or the Commissioner has provided advanced approval in respect of the travel. Now, even if the non-commercial travel is permitted, it would still need to be reported to the Commissioner within 30 days of accepting the travel offer. Under Sections 8 and 9, members, spouses, direct associates cannot accept various specified contracts or receive money from the Crown, just by way of example, borrowing money from the ATB, selling lands to the Crown, or constructing public works. But a member does not breach the Act where the Commissioner is of the view that the contracts do not constitute a conflict between the contracting party and the public interest, or would find that the contract itself is trivial in nature. So that covers off Part 2. Moving into Part 3, this is Sections 11 to 19. This is dealing with financial information the members need to file with the Ethics Commissioner, including information specified in the Act. So the Commissioner is going to discuss this part in greater detail, so I'll move through this. But before moving on, I wanted to note that there was a change last fall here as well. Section 12 was amended to establish that members must report annual benefits over a prescribed threshold in the regulation. The threshold is previously in the Act. And again, pursuant to the members' gifts and benefit regulation, the threshold is currently set at $250. Now, moving on to Part 4, just by way of structure. Part 4 is actually made up of several parts, 4 to 4.3. And just for clarification, Parts 4.1 and 4.2 were previously 6 and 6.1 respectively. These were moved up following a reorganization, and that's why, just if you look at the table of contents, the Act moves from Part 5 directly to Part 7. So, there's nothing missing per se, it's just reorganized to keep similar provisions together. So Part 4 itself, 4 prime as I'll call it, contains restrictions on members of Executive Council, including the Premier and the Leader of the Opposition. So Section 20 establishes that ministers would breach the Act if they own beneficial interests in publicly traded securities or engage in employment beyond the Act's time limit on that. So by default, the time limit by which securities need to be divested or employment need to be ended is 60 days after their appointment, although this time period could be extended by the Ethics Commissioner. In terms of securities, there's several ways in which securities could also be retained instead of being divested. First, the Commissioner could approve retention of the securities if they're of the view that the interests are publicly traded and that a corporation in which the minister owns securities would be unlikely to be affected by decisions of the Alberta government, or if the minister would sustain a financial loss if the securities are disposed of and the public interest essentially doesn't require that they be disposed. Additionally, securities could be placed in a blind trust. And just by way of what that is, a blind trust is where the minister, as the settler of the trust, gives the trustee sole power over investment decisions in respect of the portfolio and agrees not to have any decision-making or knowledge of the trust in terms of what the decision is being made. The trustee selected would need to have no relationship with the minister that would affect or appear to affect the trustee's discharge of their duties. And third, the Commissioner can approve an arrangement similar to a blind trust to allow securities to be retained. Section 21 also contains employment restrictions on current ministers, and that includes, for example, carrying out a business or engaging in the practice of profession while one's a minister. Now, the Commissioner may again allow concurrent employment if prior to the expiration of the 60-day time limit, they would find that the activity would not create any conflict of interest. Moving on to Part 4.1, which is Section 23.1, this deals with restrictions on former ministers after the time is ended in Executive Council. There's 5 in total. The first 2 take effect from the last day of appointment. So a former minister can't, within 12 months of their appointment ending, lobby any public office holder or act on a commercial basis on an ongoing matter in which the minister was directly involved while they were in office. The 3rd and 4th restrictions take effect from the last day the minister had a direct and significant official dealing with a department or a provincial agency. So for 12 months from that period of time, former ministers are prohibited from making representations on a contract with a department or agency, or soliciting or accepting a contract from that department or agency. And fifth, a former minister who's had direct and significant official dealings with an organization or a board must wait 12 months from the date of the last dealings before accepting an offer of employment or appointment to that board. Now, in all those cases, former ministers are able to apply to the Ethics Commissioner and request that these periods of time are either reduced or waived. And I wanted to note at this point as well, Section 23.13 also establishes that ministers breach this part of the Act if they knowingly award or approve a contract or give a benefit to a former minister, former staff from a minister's office, or former designated office holder under the Public Service Act. Now, Part 4.2 is moving into the political staff. This deals with requirements for the premiers and the minister's staff. They do not include administrative support, though, in this definition. So as with MLAs, staff covered by this part are prohibited from participating in decisions, using their influence, or communicating insider information to further their private interest. So in this regard, these restrictions are similar to the ones that had just previously been discussed. These staff also have similar post-employment restrictions to former ministers. The one thing to note here is Section 23.7 sub 6 makes clear that these staff are able to accept employment in a department of the public service or in a provincial agency in accordance with Part 1 of the Public Service Act. Additionally, the Premier's Chief of Staff in particular is subject to restrictions on securities, and those restrictions on securities are similar to those discussed in respective ministers. And similarly, one could use a blind trust, for example, to retain holdings. As a final note, these staff also are subject to a code of conduct, and this is established by the Lieutenant Governor and Council. Section 23.41 sub 3 of the Act makes clear that contraventions of the code of conduct are also a breach of the Act, and those have the potential to result in disciplinary action for the offending staff member. Part 4.3, getting to the end of the part 4s, applies to public agencies and subsidiaries of public agencies under the Alberta Public Agencies Governance Act, or BPEGA, as people are probably familiar with, regional health authorities, as well as any other bodies identified by the Lieutenant Governor and Council as public agencies for the purposes of this part. I want to note that the Lieutenant Governor and Council may also exempt public agencies, as well as class of positions in public agencies from this part, and specific obligations under these sections. So broadly speaking, Part 4.3 imposes several obligations on these agencies. First off, the agencies need to establish a code of conduct for staff and submit that to the Commissioner for approval, and once approved, need to publish and implement that code of conduct. The Act itself also sets out the key elements that need to be included in each code of conduct. These include, for example, prohibitions on using influence to further private interests, disclosure of real or apparent conflicts of interest where they're found, restrictions on the acceptance of gifts, as well as a processing for receiving and investigating complaints. Second, the Act sets requirements for senior officials. These would be, for example, the chair of a public agency or the CEO of a public agency or another position designated as such by the regulation made by the Lieutenant Governor and Council. So senior officials have similar restrictions as members in respect of not furthering their private interests and not engaging in concurrent employment. There's another class as well, the designated senior official, a DSO for short, that are subject to additional restrictions. Those would include post-employment restrictions, similar to former ministers or the premiers and minister staff, as well as restrictions on holdings that are similar to, again, ministers and premier staff. So in terms of where this is all found, the designation order regulation is what actually identifies designated officers and designated senior officials. Note as well that the Act is clear that designated senior officials are not prohibited from being appointed to a board of directors or a governing body of another public agency. So similar to former minister's office and premier's office, they're also permitted to accept employment with a department or a public agency following their time as a designated senior official. So before turning things over to the Commissioner, I wanted to note one final amendment that was made last fall, and this is Section 25.1. So pursuant to 25.1, the Commissioner must suspend investigations during general elections. And this suspension period begins when a writ is issued in respect of a general election, and it ends once election results have been finalized and a candidate's been declared successful in accordance with the Elections Act. Now, under Section 25.15, the Commissioner may continue an investigation that's been suspended if the person who requested the investigation asks them to do so, or if the subject of the investigation asks that they do so. Now, in either case, it would need to be within 30 days of the suspension end date. So that's the period of time in which someone could request that an investigation continue. Now, in the event that the Commissioner self-initiate the investigation that was ultimately suspended, then it would ultimately be the Commissioner who's deciding whether or not to continue the suspended investigation. But again, it would be within 30 days of the suspension end period for that decision to happen. So at this point, that concludes sort of my run through of the Act. At this point, I would propose turning the floor over to the Commissioner to discuss their office, the disclosure provisions, and the investigations in Part 5, as well as the administrative monetary penalty system. I know that there are technical questions afterwards. Certainly, I'd be happy to stay around, and perhaps the Commissioner and I could answer those together if that would come up.
That would be absolutely wonderful if you do that. And thank you so much for having such a succinct presentation. And I know the clerk is extremely happy because his timer worked. So with that, we'll turn it over to the Commissioner. Thank you, sir. Just ready to set this thing off.
Thank
Go
you,
ahead, please. Thank you.
Mr. Chair. I intend to limit my remarks today to a brief review of the more important sections of the Act and the occasional mention of problem areas and what areas are working. I will not deal with any of the recommendations in our 59-page submission that will be presented later in the process. So the main purpose of the Act is to make sure legislatures, political staff, deputy ministers, and chief executive officers of agencies, boards, and commissions do not finance.
To interrupt, I apologize. I've been advised that we need to make sure you introduce yourself. We all know who you are, but we have to get you to introduce yourself and the gentleman to your left as well, please, for the record.
Right. I'm Margaret Trussler. I'm the Ethics Commissioner, and I have my General Counsel, Josh DeGroot, with me today.
Perfect. Thank you, ma'am. Now we're good to go.
All right. So I won't start right at the beginning. The main purpose of the Act is to make sure that legislatures, political staff, deputy ministers, the chief executive officers of agencies, boards, and commissions do not financially or otherwise benefit from their positions beyond government remuneration that they are paid. So I'm first going to deal with the furthering of interest sections, of which there's two and some definitions. And one is private interest. It's a definition. And it's problematic because it's defined in the negative. You have to start with any interest whatsoever and then exclude interests that are of a broad class, general application, concerns the salaries and benefits received by a member, as a member, an interest that's trivial, and interest in a blind trust. The interpretation of these exclusions can be somewhat subjective. A private interest is usually a financial interest, but there is nothing to preclude other types of interests. And the next definition section is that of direct associates, which you've heard is a spouse equivalent, a for-profit corporation where the member is a director or senior officer, a for-profit corporation where the member owns shares, a partnership, and someone acting with the consent of the member. Now, this section is quite straightforward. The only issue that we do have is sometimes those involving corporations. So in terms of the decision-making sections, the private interest ones, it's section 2. And that section doesn't allow members to vote on matters that would further their direct associates or a child's private interests. The section's very narrow, and it doesn't cover a considerable amount of possible areas where there could be improper conduct. Section 3 prohibits a member using the member's influence with respect to a government decision which would further a private interest of the member, a direct associate, or a minor child. It also prohibits influencing a decision to improperly further another person's private interest. An example of that could be a former business partner. Again, this section is so narrow that it's actually practically useless. Alberta is the only jurisdiction in Canada to limit this section to only government decisions. All other jurisdictions prohibit using the member's office or power to influence a decision of any other person. I'll now move on to contracts and payments from the Crown. Section 8, these provisions are quite complex, but basically forbid contracts with the Crown, subject to some exceptions. Issues arise with the provision prohibiting the borrowing of money from the Alberta Treasury Branch and the Alberta Financial Services Corporation, because many people, when they're elected, already have obligations to those two institutions. We've managed to work around it, but it is something that needs to be flagged. And then Section 9 forbids payments from the Crown. however, excludes remuneration expenses as a member of the Assembly, or if it's the type of payment anyone can receive. And that's sort of the payment way back when Ralph Klein was Premier. There were Ralph bucks. Everyone was entitled to get them. So that would be sort of a across-the-board payment that everybody in Alberta would get, or even a very broad class. Part 3 deals with disclosure. It requires a listing of all assets of a member, no matter what their quality, so it also could include a contingent interest. It also applies to direct associates as defined in the Act. And as you know, we have forms to do it because it provides consistency and then you don't forget things. Close to 300 people each year have to provide disclosure, and as a result, we group them into MLA's political staff to the Premier and ministers, designated office holders, who are for the most part deputy ministers, and designated senior officials, who are the CEOs of the major boards, agencies, and commission. The provisions of the Act for the various groups are scattered throughout the Acts, and for deputy ministers, they're actually found in the Public Service Act. So each group files disclosure at different times of the year to spread out the workload and to ensure up-to-date information. And aside from those required, sometimes being late or being a bit sloppy, filling out the forms, the provisions actually work quite well. Public disclosure statements are prepared for members only. They are housed at the Office of the Legislative Assembly and also on our website. And there's only a limited amount of information that's provided in the public disclosures. It's really bare minimum. However, all publicly traded securities over $10,000 are listed, and real property is listed but not indicating where that property is. No addresses are provided. There are special provisions for Executive Council. The first ones are in Part 4, that members of Cabinet cannot be involved in a business unless they have to meet certain professional occupational standards. For example, doctors have to keep up a certain number of hours per year, and they can't hold publicly traded securities. Businesses must be sold, or they can be placed in management trusts, and publicly traded securities have to be put into blind trusts. The trustee has to be at arm's length from the minister. And so we vet both the trustee and the agreement to be vetted and approved, and we have to approve them. Now, there are some issues that arise, and that's with residential rental property because of the expense of having a trustee, and also with farming businesses. We've managed to work around those, but it's taken a bit of a stretch of the Act to do that. The other section with respect to Executive Council is 4.1, and that's the post-employment restrictions. They last for a year. The provisions are insufficient, convoluted, and almost impossible to interpret. They prevent lobbying or anything that looks like lobbying, even if it does not meet the definition of the Lobbyist Act. The reason they're put in is you don't want somebody in a position of power as an MLA at one particular point of time, and then a month later, when they're no longer an MLA, they're walking the halls lobbying for someone and have an unfair advantage because they know everybody. It also prevents receiving government contracts in a limited way, and that's something that comes out of the Klein area where many people were let go, and then they got fairly nice consulting contracts afterwards. And it prevents someone from taking a position, prevents taking a position for someone with whom the minister had a direct and significant dealing within the last year, and that prevents, say, a minister on purpose or inadvertently giving a benefit to somebody and then taking a job with them. For political staff, that's political staff to ministers and to the Premier, political staff to caucus and the opposition are not covered by the section, and in some cases this creates an unlevel playing field. Political staff also have to do disclosure and submit direct associates reports, and they're subject to the post-employment restrictions of 1 year. That could be eased a little bit because it has caused some problems which we managed to get around, but even so. Public agencies is 4.3, and the majority of the public agencies are required to have codes of conduct. A designated senior official is the most senior official of an agency and usually the CEO. And designated senior officials have to provide yearly disclosure, have blind trusts for their publicly traded securities unless they have an exemption, and are subject to 1 year post-employment provisions. Not all public agencies have designated senior officials. There are only 36 of them, and they are the most prominent of the public agencies. These actually are useful standardizing provisions, giving agencies needed oversight, and they work quite well. Deputy ministers are covered by the Public Service Act, Part 3. They have to do yearly financial disclosure. They have blind trusts for publicly traded securities unless exempted. And they're also the same post-employment provisions as found in the Conflicts of Interest Act. Again, the provision for post-employment is somewhat convoluted, and there are some exceptions that need to be made. Investigations, Part 5. There are also provisions in Section 23.8 and 23.94, and the power of the Commissioner in obtaining information on investigation and compelling witnesses are extensive and are necessary. They're also very clear. The general public must make a request in writing, and the person making the request must sign it and be identified. And generally, requests come by email, and as long as the person's name appears on the email, the request is considered. But I have to tell you that most of the requests from the public do not pertain to matters within the office's jurisdiction, and we inform them of that. The Legislative Assembly, by resolution, may request an investigation, as may the Executive Council. That's never happened. The Ethics Commissioner may also investigate if there's a reasonable belief that someone subject to the Act has acted contrary to the direction or advice given. Everyone being investigated must be given notice of the investigation. Now, the Speaker's usually informed, not necessarily, but that's usually to stop questions in the legislature and also in committee. And if a law enforcement agency is investigating, the Ethics Commissioner suspends any investigation until after the law enforcement agency has completed theirs. The Ethics Commissioner can refuse to investigate if the matter is not within jurisdiction, which is probably 90%, 95%, is frivolous, vexatious, or not made in good faith, and that does happen too, or there are no grounds for an investigation, and we do see that as well. Investigations made under Part 5 the reports are filed with the Assembly, with the Speaker, and the Speaker tables them in the Assembly. As a matter of practice, reports are provided the person being investigated shortly prior to being sent to the Speaker, unless the allegations are found to be substantiated, and then the person's given time to respond prior to the report. And usually at that point they have legal counsel involved, and we give legal counsel time to make a response. Now, investigation reports with respect to political staff only go to the staff member's minister. They're not made public. And likewise, investigations into conduct of designated senior officials are only sent to the minister and the chair of the agency board. The situation is similar for designated office holders, where the report goes to the Deputy Minister of Executive Council, or if it is the Deputy Minister, then the Premier. In some instances, the person making the request receives a copy of the report. In other cases, they don't. So there's quite a bit of inconsistency. All investigations are done with as much confidentiality as possible, which on occasion causes issues and lack of transparency. And I'm of the view that all reports should be made public. Administrative penalties are found in Section 30.1 of the Act, and the Commissioner can impose penalties for late disclosure to a maximum of $500 per occurrence. The practice is a penalty of $50 a day after a short grace period until the filing is complete and the $500 is reached. And a repeat offender might start with a penalty of $100 a day, but there's only a very small group of MLAs that are late filers. Most MLAs are very diligent in getting their disclosure filed. That's all I have to say on the matter, but I'm certainly be willing to entertain any questions.
Perfect. Well, really appreciate that, Commissioner. And with that, I'll turn it back to the members. We have about 40 minutes for that, so whoever wants to start asking questions, please catch my attention, and it goes for both of our presenters here today. Emily Long.
Sweet. Thank you, folks, for taking the time to be here today. Really appreciate not only a bit of an explanation to some of the things in the Act, but also some opinions as well. Inevitably, I assume the people today are quite a bit more familiar with the Act than I am. So I appreciate your expertise, and I know that we've had numbers of discussions where, Ms. Tressler, you've always been willing to give guidance on how to view the Act. So I appreciate that. Now, obviously, the Act itself is quite broad-ranging in scope, and I know the Act was expanded in 2017 to include not only ministers, members, and senior staff, but also employees of agencies, boards, and commissions. And I believe that the number's over 300 folks on that list in total now. So I was hoping that either from the ministry or from the ethics commissioner, you'd be willing to speak to what might have been the rationale behind the expansion, and also speak to whether the mechanisms set out within the Act are efficiently able to manage such a large range of individuals and positions.
I can answer that. Actually, the political staff were added in the fall of 2014 when Jim Prentice became premier. I think it was his Ottawa experience and also his chief of staff believed that political staff were very close to the sources of power, and that there should be some restrictions on them. So that's when they put in the code of conduct, and they also put in the provisions in the Act. The agencies, boards, and commissions were placed under the Act, I think you're correct, in 2017. I think it's because there was a bit of a Wild West show with the agencies, boards, and commissions going various directions on various things. And there were instances where conflicts arose, where a member, a CEO of an agency, board, and commission was sitting on a board, an outside board, and then there was a conflict with respect to that outside board at the CEO's place of business. You will remember shortly thereafter, we did the investigation into the CEO of a major board, which was the Alberta Energy Regulator, and it was found that there was some pretty scurrilous conduct going on. So I think it was put in for those sorts of reasons, that there were instances, there was uneasiness that then proved to be true, that there needed to be some oversight of those agency, boards, and commissions, what their outside activities were, and also what they were up to in terms of other businesses while they were holding this important government role.
Follow-up?
Yes.
Okay, sure, go ahead. And then I have MLA Sabir followed by MLA Wright on the speaking list.
So I'm also aware that designated office holders, mainly deputy ministers, have provisions under the Public Service Act that are in some ways analogous to those in the Conflicts of Interest Act. I was wondering if you could provide an overview of the similarities and differences between the regulations placed on designated office holders through the Public Service Act and the regulations within the Conflicts of Interest Act.
Should I answer that? Yeah.
So in terms of the deputy ministers, the most significant overlap, they have similar restrictions on holdings and similar restrictions on post-employment restrictions as ministers do. So they are located in two different acts, but they are broadly mirroring each other right now. And along with that, they sort of have the same general restrictions in respect of not furthering their own private interests and so forth. And in terms of, if there was a question about how those might evolve in the future, the Public Service Act could certainly be amended separately if there was a desire to, have some of them different from ministers. There would also be the possibility of keeping them mirrored as well.
MLA Sabir, go ahead.
Thank you, Chair. I have some questions, and I will start with Justice Department. Thank you, Mark, for a nice overview of the Act. I'm just wondering that if the department will be making any recommendation, any areas that you think that need to be changed.
I believe if we're invited to make a submission, I'm sorry.
Just to interject here. Again, I kind of said at the start of the meeting, MLA Sabir, so just as a reminder, right now the individuals are here in the capacity of technical advisors, not as stakeholders. So they'll have a chance later on with the committee to engage a stakeholder. So just to caution you on that, and however you want to answer that question.
And, I think I was probably going to say sort of the similar thing. I wouldn't be able to sort of bind the Department of Justice myself in that respect, though I know that if requested, Justice has made submissions to similar committees in the past. The one observation I would have, though, is in terms of the actual administration, Justice, amends the Act, but the Ethics Commissioner administers it. So certainly she would probably have more recommendations on that side than we would.
Sabir, do you have a follow-up question?
Yeah, sure. And that's fine. Not from Justice. I will move to Ethics Commissioner. And thank you, Commissioner, for being here. And you also indicated that you will be making submission, so I look forward to that. But I do want to talk a little bit about Section 2. You said that it's fairly narrow in its scope, and it only impacts minister if they're making or using their office while making a decision as part of the executive council or some government decision, but not if they pick up a phone and call somebody to further their private interest. Is that correct?
3.
Yeah.
It's Section 3.
Section 2.
In Section 2, it does say it takes part in a decision knowing that it might further a person's private interest. The words speak for themselves. That's what it says, that if you take part in a decision, vote on a decision, and it's going to line your pockets or that of someone very close to you, then it's forbidden by the Act.
And are there provisions?
So MLA Sabir, the way I'm going to run it here today is one question follow-up, because there's a lot of folks throwing their hands up, if that works, and if you want to go back on the list, I can throw you back on again. So right now I have MLA Rosewell and IP, and if you want to go on again, Ephraim, I can throw you on again if you want right now.
Yeah.
Okay, thank you. MLA Wright, I had you at the start. You want to know?
Thank you both for taking a question here, and Mr. Chair. When I was reviewing the Act, I was really trying to grasp as much as I could to be as informed as possible, to ask, I think, some very meaningful questions to better understand from the government side of things. My background comes from business. We've dealt with various different levels of conflict of interest acts over my time in business. In the Act, I see that there is a number of references pertaining to legal proceedings within the Act, particularly in context to legal expenditures that may be incurred as a result of an investigation. However, I don't see the ability or right of any individual to seek legal representation specifically stated anywhere in the Act. So from that started raising a number of questions for me, because within our system of democracy, usually if there's questions of legal proceedings, there should be some form of representation present. And I found it kind of fitting that you had brought your general counsel with you here today. So is there a specific clause in the Act that speaks to the ability, or perhaps the right, for an individual who is subject to an investigation by the Ethics Commissioner to seek legal representation and or counsel with regards to the investigation?
There is not, and there is an argument that because it's just an investigation or report and the legislative assembly makes the final decisions, that they're not at risk. I don't follow that view. If anyone wishes to have legal counsel, we deal with legal counsel, and we allow legal counsel to be present. And in our letter to them, we do say that legal counsel is permissible. It's just because there is a jeopardy, even though I'm not the final decision maker, I think it's only fair as a matter of natural justice that someone would be able to have representation.
Perfect, thank you. I do have one follow-up, sir. More broadly, in situations where the Act does not specify a requirement, how are operational decisions made to ensure proper functioning of the Act in these types of situations?
Not sure I understand your question.
I think it's more like in broad situations where, let's say, the MLA's yearly review gets done and submitted. In situations where it does not specify a requirement for counsel, would there be openings for that MLA to bring counsel to even that meeting, let's say?
It's happened.
Okay.
I never would, I guess it's my background, but I would never deny anyone the right to counsel. The exception is sometimes witnesses on an investigation, people I just want to question and talk to, want to bring counsel. They're not entitled to counsel. But anyone who's going to be directly affected is always welcome to bring counsel.
Perfect, thank you.
Emily Rosewell, you're next.
Okay, I think I'll go to this question. In Section 20 of the Act, the Minister may not have beneficial interest in publicly traded securities without the Ethics Commissioner's approval unless it's held in a blind trust. And I just have a few questions relative to that. I know, so relative to mutual funds, like there's individual securities within there, is that like, are they allowed to have that because they're not influenced that way?
Mutual funds and exchange-traded funds, we consider like mutual funds, do not have to be in a blind trust.
And then Section 20.3 provides some criteria under which the Ethics Commissioner may approve the holdings of, and it was mentioned in the presentation, where they could hold it, where it might require, if they sold it, it'd be a loss, and
I usually require them to go into a blind trust, and it's mainly for perception purposes.
Okay.
Because otherwise, it protects them to have it in a blind trust if they have publicly traded, a minister, to have it in publicly traded shares. Doesn't then appear on their financial disclosure. It also means that it's funny, I think people had too much time during COVID, but there's always somebody looking to pick at people. And so it sort of gets rid of that sort of nitpicking, irrelevant type of harassment. So it's really in their best interest to put it into a blind trust. And the ministers' departments actually pay their legal fees or their trustee fees when it's in a blind trust. It's sent to our office, we approve them unless sometimes we question them if the legal fees are really high, but for the most part, we just approve them. And then the minister does not have any costs related to having their publicly traded securities in a blind trust.
And I have MLA Ip, Sabir, and Long, and Rosewell. If you want back on the list, I can throw you back on if you have more questions. Okay, and Lovely. MLA Ip, it's all yours.
Thank you, Mr. Chair, and thank you, Madam Tressler, to you and your team for being here today. You had mentioned that some of the provisions pertaining to post-employment restrictions were convoluted and difficult to enforce. I just wanted to perhaps gain a better understanding of what some of the reasons might be. You did mention that certainly in your testimony, but I'm wondering if you could elaborate or enumerate on some of the difficulties. Is the language, for example, in the Act perhaps too narrow or not sufficiently clear? Just wanted perhaps some additional context.
Well, I don't think I want to go into detail today because this is just a technical briefing. I didn't say they were difficult to enforce, they're difficult to understand. So people who are in that position, they always phone us and they say, what can I do? What can't I do? And just because it's not very straightforward language. There was one section, it took me 5 years before I finally figured out what they were trying to get at, and then it made some sense, but it just doesn't read that way. And so I think that it could be, the language could be simplified so it's easier for people who are subject to those provisions so that in advance they can understand those provisions.
Thank you very much.
Did you have a follow-up as well? Okay. We're over to MLA Sabir, followed by Long, Rosewell, Lovely, Wright. You guys are full of questions today.
Thank you. I don't know if my question will be beyond the scope of this technical briefing, but I was going to ask about Section 2. It's mostly follow-up to the previous question I had. That, Commissioner, my understanding of this section is that it applies to the decision of minister, participation of minister in a decision of the government. But are there any examples from other jurisdictions where they are doing things differently? For instance, if minister does something using his office to further his private interest, are there provisions anywhere else that deal directly with that and not in the course of decision making as part of government?
Cross-jurisdictional survey. I do know that some other provinces have different wording in their acts, but I couldn't tell you across Canada what they are.
Okay. And
to that MLA?
I think the questions will be kind of similar. Other question was same. You identified issues with residential property and farm property, dealing with farm property. I was going to ask that if other jurisdictions are doing it differently and you have any recommendations about that.
Again, I haven't done a cross jurisdictional study on that issue. We have looked on some of them, which will show up in our recommendations. I just mentioned those because of the impracticality. If you have one rental property and you're a minister, it's a business. So you're supposed to put it in a management trust, and it doesn't seem to make a lot of sense. And during the last review of the Act, I had suggested that perhaps that should be an exception.
Thanks for that. MLA Long, you're next.
Thank you for that. I'd actually, I've only been around for 5 years in the position, but I actually appreciated your comment earlier about maybe people had a little too much time and they were trying to nitpick during certain times over this past 5 years. And so with that in mind, I'd like to speak about the process in the Act regarding investigations being carried out by the Ethics Commissioner. And I've noted a number of times after the fact that in a response, you have cautioned folks and even urged people to remember the scope of the Act and the purpose of your office prior to bringing forward complaints and that sort of thing. So I'm just curious, when the Ethics Commissioner receives a complaint or a request to initiate an investigation, what matters fall under the jurisdiction of the Ethics Commissioner? What is the process and criteria under which the commissioner determines whether the request is valid and whether to begin an investigation. I'll just start there and then I'll have a follow-up.
It's really a matter of statutory interpretation. So the request is brought into my office, and sometimes it's just so far out of jurisdiction, you know, immediately. Sometimes it's obvious, but it sounds valid, but you know it's not within the jurisdiction. They have a legitimate complaint, not our office. They have trouble understanding that because they think everything's a matter of ethics. They don't realize what we deal with is the conflicts of interest. And sometimes I think that the office is misnamed. It should be the Conflicts of Interest Commissioner and the Conflicts of Interest Office. Not that I think that would do a lot of trouble, but we do have that issue with people. Sometimes we don't know because we haven't got enough information, so we sometimes will ask them further information, and when they get back to us the second time, we will say, yes, there is something here, or we'll say, no, there isn't. Sometimes we'll do a preliminary sort of look at it to see if we should do an investigation, but we're very careful to make sure that they give us sufficient facts before we start doing an investigation, because quite frankly, we just don't want to take a shotgun approach to things. We don't want to go on any witch hunts. We want to make sure that there are enough facts that it would substantiate that there may be an issue. And once we decide that there's probably an issue, we write a letter to the person to say that's being investigated, they're being investigated, and we give them time to provide us with documents, and then they usually have counsel contact our office.
Thank you for that follow-up, please. And actually, I appreciate the, possibly the clarity around the office title being Conflicts of Interest Commissioner or whatever. I think that might be a little more helpful, so thanks for that. But I'm curious, and again, I rely on the expertise at the table for this. Is there a penalty set out in the Act or otherwise for an individual who makes a frivolous request? And with that in mind, like, again, I've heard some of the things being brought forward to the office, and at times I personally, my perspective is that it's evident that people are seeking headlines as opposed to bringing legitimate requests. And so with this in mind, if there is or isn't a penalty, should there be or shouldn't there be, I guess would be my attachment to that.
MLA hesitate to interrupt, but and again in the capacity of the technical
Stakeholders,
advisors
I know,
versus stakeholders.
Okay, so just the first one would be fine.
Okay. Thank you.
Is there
I got
is there
lost
a penalty in the Act for
we just
frivolous complaints?
say, no, we're not going to do it.
Okay, thank you.
And so that's the end of it. Well, that's often not the end of it. Often we get an abusive email back. But if it's not within the Act, it's not within the Act. Many people disagree with us, but if we've made that decision, that's our decision. And we're not going to investigate. We're not going to chase squirrels up every tree.
Thank you so much.
Excellent. MLA Rosewell, followed by Lovely and Wright. And if anyone else wants on the speaking list, please let me know.
It seems to me that referring specifically to Section 24 and 25 of the Conflict of Interest Act, there may be some concern around the role of the Ethics Commissioner being tasked with investigating potential breaches and as well as ruling on them. And so I was just wondering, it's kind of might be the common phrase of being prosecutor and judge. And, so like which of the course leads to the questions of fairness and process. So I'd like to ask the Commissioner, if that's her impression, is there other mechanisms to ensure investigations stay as objective as possible?
Well, we don't have both roles.
Okay.
We do an investigation, we write a report with our findings. The person who makes the body that makes the decision is the Legislative Assembly. And that's pretty clear in the case law, that we are not making a decision. We are just giving an opinion as to whether we think the Act has been breached or not. And it's up to the Legislative Assembly. if we say it's breached and if we recommend a penalty, or even if we don't recommend a penalty, it's up to the Legislative Assembly to make that decision.
Good.
You have a follow-up,
No,
MLA?
that's good.
Okay.
She answered both.
MLA Lovely?
Thank you, Commissioner. You do many interviews, and you had spoken earlier in our meeting today about a blind trust, and so I'm wondering if holdings are kept in a blind trust, does the Commissioner list each investment in detail for public disclosure? And is there the ability for people to appeal a decision made by the Ethics Commissioner after an investigation and report is finalized, including both when a penalty or no penalty has been set? And is there a specific process or requirements in the Act? And could the Commissioner please outline the process an individual would have to follow in order to have an appeal?
Well, because I don't impose the penalty or make the decision, it's the legislature that does that, then there's no appeal because it's the Legislative Assembly, cannot be judicially reviewed.
And so just to go back to my first question, do you list the, in a blind trust, each investment for public disclosure?
If it's in a blind trust, then it doesn't appear on the public disclosure.
Fantastic. Thank you. That's all my questions.
Thank you. MLA Wright and MLA Long once on the list again.
Thank you, Mr. Chair. Ms. Tressler, earlier you had mentioned when folks that have a farming business, that there's often workarounds that need to be done in order for things to stay above board, we'll say. What do some of those examples that you've used in the past look like as to, I guess, keep things above board?
I have to be careful to give about examples because
Yeah,
I might reveal confidential information, but we have been known to tell farmers that what they do in the weekend is not our concern. We have been known to allow spouses to be the trustee in some businesses, or a family member to be the trustee, or the accountant for the operation to be one of the trustees. So it's not been quite as arm's length as the Act might suggest, but there's no other way you can do it because of the way the farms operate.
Follow-up?
No, she answered even my follow-up question.
Perfect.
So thank you very much.
MLA Long?
And just to confirm something, one of the areas you touched on earlier was about members not allowed to vote on things that directly impact them financially or otherwise, I believe. This context, I just wanted to confirm, goes beyond the Assembly into committee as well, does it not? Yes. Okay. Thank you. That was just...
Are there any other questions? And we didn't have a single question for Mr. Aman. Oh, sorry. Oh, we do. Excellent. MLA Brooks Arkan Paul.
Thank you, Mr. Chair. So once again, I'd like to make a question about the rules on gifts and when they'll be published. I just wanted to see what the details will be on that and where we are moving as members, just so that we are very aware of our responsibility with the new changes to the gift rules.
I think they've already been published, and we have already changed all our forms online and put an explanation online. So it's really up to the members, I think, to educate themselves on the new rules.
And just sort of for reference, the members' gifts and benefits reg would be that's adjacent to the Act and subservient to the Act that would have some of those rules in them. So the regulation would be recommended to be reviewed as well.
And thank you so much. I just, pardon Chair, I'm not sure the rules around asking up my follow question. I'm just clarifying, right?
Yeah, you can clarify if you wish. I don't see anyone else on the list, so I'll give you a little bit of latitude as well. And I'm not sure if you heard the full answer from Mr. Mark Ammon as well. So if you need clarity on that, we'll allow that question to be asked again, just so you can catch that, Brooks.
Okay. I did catch that, so I appreciate the response. I am curious, and this is for the commissioner, just about the use of blind trusts. So in my work as a lawyer, I know that blind trusts are often used for various purposes. And in this case, I'm just wondering, does the commissioner have the latitude to do investigations into these blind trusts? Because my concern is the level of latitude that is given when a member or a minister or the premier might have something established that is in a blind trust, that sometimes the connections that might be in these investments or in other types of interests. I worry that there might be some level of ethics concerns. And I was just wondering if the commissioner does investigate those instances of blind trust, or you leave it at that with respect to the legislation and with respect to the rights that you have as the commissioner.
Well, I don't have the right to initiate an investigation, although I suppose I could do it on the basis they haven't followed my advice in terms of a blind trust. But situations never arisen. People put their publicly traded shares into blind trusts. The trustees are told that they send the statements directly to us each year for public disclosure. They don't, for private disclosure, they don't send them through the minister. I've just never seen where there's been an instance of any sort of difficulty.
Are there any other questions from committee members? Going once, twice, closed. Thank you very much. Oh.
I was trying to mute.
We'll take that as a bit of a delay. I'll have a voice delay on the telecom. So over to you, MLA Summer.
Also, just a clarifying procedural question, that when we submit the disclosure, it takes a fair bit of time to get them posted publicly. So there is lag per se. Are there any specific reasons for that? If Mr. want to answer.
Actually, there's not that much of a lag time. When I first started, we saw all the MLAs in May and June, some of them having to drive many hours because the legislature wasn't sitting. And then in November, you received your public disclosure statement, and you had to remember what you'd done in May and June and review it and let us know. And then they were all filed with the clerk of the Legislative Assembly. That was changed so that we actually had to publish on our website the public disclosure, and we changed it so that you do your disclosure when you come in for your meeting, which it might be a month afterwards, it might be a bit longer, but it's within 6 weeks, that when you come in for your meeting, the public disclosure is done already, and then as soon as your meeting is finished, it's updated online. So instead of being a 6-month lag, now it's no more than 2-month lag between the time that you file your disclosure and we do the public disclosure. And honestly, if people have changes in that time, they're very good about telling us that they've had a change within that time.
Do you have a follow-up, MLA Sabir?
No, thank you.
Okay, and if I call it again, you're going to get under the wire, or? MLA Rosewell.
I'll keep it unmuted.
MLA Rosewell, you're up next.
Now, part of it is just, again, relative to blind trusts and, giving money and your decisions over to someone else and you can't communicate with them, and it's, that's quite a thing. I was just wondering, maybe the ministry can explain why that's seen as reasonable recourse when the act was drafted, and how it serves the purpose. Now, I know the commissioner said it kind of protects us from public, that conflict of interest accusations or that type of thing. But just kind of want to understand how that got going and how it prevents conflicts to be caused.
And I think, so the blind trust provisions, I think are, like, they've been in there for quite a while now. And ultimately, I think the main focus with these sections is that if one has a financial interest in a decision, one isn't sort of making a decision with clear motivation with respect to financial interest rather than, the public interest, for example. And if things are set in a blind trust, then you don't have that type of direct knowledge where it could be clouding one's decision making. So that's kind of the rationale for that. And that's why it's sort of perceived as an alternative in respect of, if there was a interest that the government of Alberta decisions couldn't possibly affect. Likewise, a blind trust there wouldn't necessarily be the recourse because there's no real possibility of conflict, then that, they would sort of complement each other in that respect.
All jurisdictions have this provision, and it's they've been there since the beginning of legislation because it was felt that it was necessary. I certainly wasn't part of that decision making, so I don't know what went into it. But I think part of it is you never know when something might come up where you actually that might affect a shareholding that you have, so that if it's all in the blind trust. Now, I tell the trustees that they can, if somebody has a portfolio, that at the end of the year, they can tell the minister the bottom line, not what each of them done going up and down, but they can tell them their bottom line so they have a comparison from year to year. And also, ministers have to have T5 slips and T3 slips for the purposes of doing their income tax. And again, if the trustee sells something, although I don't think that happens very often, but if a trustee sells something, then there may be a capital gain or capital loss, and the minister would have to know that for the purposes of complying with the Income Tax Act.
MLA, okay, MLA Arcand Paul, I see you. You're up next, sir.
Thank you so much, Mr. Chair. Sorry, Commissioner, now that I'm having more fulsome discussion on this, I see maybe a potential avenue for all members to be considering entering into a blind trust if that is the case. Is that something that would be recommended that we do as members in potential circumstances where there might be alleged conflicts?
To interrupt, MLA Arcand, it's a technical question is what we're asking in the capacity. As I'd mentioned earlier, we're going to have a chance to have these same folks back as stakeholders, give recommendations, etc. But if it's a technical question on the Act, that's well within the course of what they're doing today. So you might want to consider rephrasing the question.
I'll retract it until they return as actual stakeholders. Thank you.
Okay, perfect. Thanks, folks, for doing that. Any other questions? Sabir? Give you a chance for the trigger finger? Okay. Really appreciate everybody today for your presentations and taking and answering our questions. You're more than happy to stay around and enjoy the tomfoolery that's taking place this morning on a Friday. But if you have other places to be, we definitely wouldn't hold you back from that. So thank you again. All right, for the rest of us, we're on to some decision items here. We have a stakeholder list. At our last meeting of the committee directed the Legislative Assembly offices to provide a draft stakeholder list related to our review of the Conflicts of Interest Act. This was posted on the committee's internal website. Members had an opportunity to review it, and at that time, I would like to ask Dr. Christina Williamson with LAO Research to provide us an overview of that document.
Good morning. I'll be brief. Basically, this list is of people affected by the legislation, of course, stakeholders, as well as other experts. So the list includes ethics commissioners from across Canada, interested advocacy groups and professional associations, some research institutes, and other ethics experts. Additionally, as I mentioned before, the stakeholder list includes individuals subject to COIA, and this includes members of the Legislative Assembly, except those who are sitting on this committee, staff in the Premier's office or the Minister's office who are not providing basic administrative support, and we've talked a lot about those political staff today. Designated office holders, which includes deputy ministers and a few others, as well as public agency chairs, CEOs, and other senior officials. So that's the list, and yeah, Thank you very much.
Perfect, thank you for that. Any questions, comments, concerns from members? Online? Hearing none and seeing none. Thank you so much again for joining us and bringing us up to speed on that. And having reviewed the stakeholders list prepared by research, do any committee members have any comments or motions that they may like to make? MLA Roswell.
Yeah, I'd like to add a person to the list, so I need to, and that wasn't done prior to the deadline. So I'd like to make a motion. I'll just read it out here. Move that the Select Special Conflict of Interest Act Committee permit a motion to be moved without prior notice, having given pursuant to Standing Order 52.041.
Yeah, so do we? Just a moment of clarity here. So, MLA, so I understand you're following the procedure right. We had another committee where we had to go through this a couple times. Just to clarify, you're asking for the one to be added, not a bunch.
No, actually, what I'm asking is for the right to introduce a motion here today,
Okay.
as opposed to, and then I'll follow that up with.
Yeah, understood,
the
and
other-
that's
yeah.
for one motion subsequent to the one you're asking now?
Yes.
Okay, perfect. Okay, so maybe we'll get the, oh, sir, go ahead, Nancy.
Thank you, Mr. Chair. So just to clarify, you are seeking the committee's approval to move a motion that would add a stakeholder to the stakeholder list.
I'm asking to move a motion to allow me to make an amendment.
To the stakeholder
yes,
list.
yeah.
We need to clarify what the purpose of the permission
Yeah,
is.
okay, fair enough.
good. Thank you.
Perfect. Okay, we'll let our folks here at the table just quickly draft that up. If anyone has an opportunity to grab a beverage, this might be a good time. The chair would give us 2 minutes, let's say, because we haven't had a bio break either. So 2 minutes, quick break, and we'll get it on. Holy crow, you guys are fast. I was trying to buy you some time. Take 2 minutes, MLA Long. I've been seeing you being Nancy. And we'll just make sure that everything's comfortable here. MLA Rosewell, if you want to make sure that's good on the board. patience. MLA Rosewell, we have what we believe is the intent and a methodology to move forward with this. So if you could just take a look at that on the board and then reread that back into the record here for us.
Okay, so that's what we discussed then, right? Yeah, okay. Okay, I'd like to move that the Select Special Committee of Interest Act Review Committee permit the following motion to be moved without prior notice, having been given pursuant to Standing Order 52.041. That the Select Special Conflict of Interest Act Review Committee amend the draft stakeholders list by adding Dr. Randall Mork, Professor, Alberta School of Business, University of Alberta.
Okay, and having heard the motion, is there any discussion? Yeah, MLA?
Just a question. It's pretty self-explanatory to me anyways, but I just want to clarify that the motion pertains only to specifically adding Mr. Mork to the stakeholder list. Does not then allow in the future to add stakeholders without any other motion, right? Is that accurate?
Yeah, that's correct. So we had a bit of deliberation at the table to make it as seamless as possible, and you're 100% spot on. This is for adding an individual with a motion to allow it to come from the floor to amend it. It's not to add subsequent other ones. We would have another motion to do that.
Okay, thank you very much.
MLA Lovely had her hand up, and then MLA Arcan Paul following.
That was my question, so thank you.
Perfect.
Yeah.
MLA Arcan Paul?
Yeah, thank you, for Mr. Chair. So just to the member, I am curious as to relevance of this potential stakeholder. So if I could just get some more clarity on the relevance of the Dr. Randall Mork to this stakeholder and the addition, I would appreciate that.
Sure, and just to clarify, so this one is to allow it to come from the floor, and then the subsequent motion from that is where we can ask those questions. If you're comfortable with that, MLA Arcand?
Well, I'd like to have that understanding before I agree to moving this potential point.
Yeah, correct. So I'm being advised by the table here that the initial pass is to accept it to come from the floor. Then we can go to the actual list, and then we can have that conversation, that deliberation for the intent and the rationale for the person, and have a very fulsome debate as required.
Chair, if I may.
Sure, go ahead, MLA Sabir.
Just a clarifying question. Does this motion need majority of the committee or unanimous decision?
It's required for majority for this motion. So any other further discussion or clarity? Okay, I am prepared to call the question. So all of those in favor of the motion, please say aye. Aye. Any opposed? Going to those online, please say aye.
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 Any opposed? Motion's carried. Now you can go ahead and move your motion for subsequent. Go ahead.
Okay, so the next one was going to be relative to this individual. So, yeah. Now this is the amended stakeholders list, right?
So move the motion to add Mr.
Oh, okay, I'll do that one then, okay. I'd like to move that this Select Special Conflict of Interest Act Review Committee amend the draft stakeholders list by adding Dr. Randall Mork, Professor, Alberta School of Business, University of Alberta.
Here we go. Now, having heard the motion, any discussion? I see MLA Arcan Paul.
Thank you, Mr. Chair. So just clarifying the relevance of this potential stakeholder, I'd ask the member that moved this just for clarification on the addition and the substance of the conversation that we will be having with this stakeholder.
Yeah, Dr. Randall Mork holds the Stephen A. Jaroslawski Distinguished Chair in Finance and is a Distinguished University Professorship at the University of Alberta's School of Business. Professor Mork holds a BSc in summa cum laude in Applied Mathematics Economics from Yale and a PhD in Economics from Harvard. The Social Science Research Network ranks him 56th most highly cited business authors in the world. He has advised governments of Canada, Chile, Israel, and the United States, as well as the IMF and the World Bank. Professor Mark studies corporate governance and the functions of financial markets and institutions and world financial history. And as an expert in economic legal matters, Professor Mark can provide valuable and unique insight to the committee, particularly on holdings and other financial restrictions in the Act.
Perfect. Any follow-ups, MLA Arcand?
Yeah, I just wondering what the relevance to the review of the Conflicts of Interest Act would be. I think I heard it in the tail end, but could the member expand on that?
Well, I guess his history will enable us to understand what restrictions might be placed on individuals within the Conflict of Interest Act.
MLA Ellingson also has a question.
Sorry about that. Yeah, I guess my question is around timing. We did receive the draft stakeholder list quite some time ago, and did have ample opportunity to review and put forward suggestions. And I'm just curious, why today? Why not in any time in the last, say, month?
Yeah, maybe I can kind of jump in there. So parliamentary procedures is no different than having amendments in the House. We have, as the committee, we requested to have these things in advance notice, obviously, so we don't have to type a bunch of these at the front of the desk. But as far as being parlance and those things, it's completely up to the members how they want to manage that. So just understanding it's well within the bounds. If they happen to move an amendment or something that may or may not have been in advance, it's just course of business. So I'll allow anybody who wants to respond to that, but through the chair, that's kind of how this stuff works. MLA Wright, you had a...
Yeah, I think, as we're kind of processing what was brought forward today by Justice and and by the Ethics Commissioner, and knowing that, many MLAs have holdings both financial, like the conversation of mutual funds that were brought up earlier, as well as the individual ownership of business. I think somebody of this magnitude of expertise from the financial and business side would be a valuable asset to be bringing an expertise that can better guide ultimately the protection of the public and the members of the legislature by giving very distinct recommendations and feedback that keep everything above board. It would be kind of my interpretation as I'm just kind of reading through some of these pieces and seeing the motion. I think that there's a number of questions that have been raised over my short time in my first term, specifically around mutual funds and the burdens that could possibly come to the members and the public in regards to trust. So I think there is definitely some pertinent experience that could be utilized from this individual.
I have MLA Sabir. You've got my attention as well. You're up next, sir.
Hey, thank you, Chair. I have similar question what my colleague was getting at, MLA Brooks. Like, this professor has an impressive resume and work history, everything. But again, like through this review, what we are trying to get at is to improve the conflict of interest, not getting, per se, business advice. So I still don't see the direct relevance of that work to this review. If MLA Roswell wants to kind of expand on it a little bit more, please, that will help us make decision.
Okay, I've got MLA Long is next, and then I see Roswell after that.
Thank you, Chair. Actually, I appreciate this motion and this stakeholder being brought forward, especially, I know earlier we were sort of jumping the gun from a few folks as far as the, having the ethics commissioner here and some of the questions being posed to her. And I believe it was MLA Arcan Paul who had suggested the possibility that MLAs should be required to put their assets into a blind trust. And I think that this person in particular might be able to give us some guidance around the mutual funds and assets and investments that we might have, and why largely some of those things are already protected enough that we don't have insight, and as provincial politicians really don't influence investment portfolios to the extent that maybe we're already okay. I don't know. I'm assuming that with this person's knowledge on those mutual funds and how they interact, it might answer some of those questions around whether there's a necessity to see MLAs required to put their assets into a blind trust. So with that said, I strongly support having this stakeholder present so I can ask some of those questions for clarity.
Sorry, Hansard keeps touching the button before I do, so good job, guys. MLA Rosewell, do you want to respond back to your colleagues? And then,
I think they've expressed it quite well, just what, we should accept, as much expert advice we can get to make sure we got this right, so.
Okay. Yeah. So with that and having the deliberation and the debate going back and forth, I am prepared to call the question. So those all in favor of the motion, please say aye. Aye. Any opposed? Online, those in favor?
Aye.
Opposed? Hearing none, motion carried. Any other possible? MLA Rosewell.
Better. I'd like to move that the Select Special Conflict of Interest Act Review Committee approve the draft stakeholders list as amended.
And that was on notice, so no typical changes to our regularly scheduled programs. Any discussion for that? Seeing none, I am prepared to call the question. All those in favor, please say aye.
Aye.
Any opposed? Online, all those in favor?
Aye.
Aye.
Opposed? Hearing none, motion carried. Honorable members, we have now agreed to the list for the committees that we wish to engage in similar reviews. Committees have also invited written submissions from the public. I would like to open the floor to a discussion of whether the committee wishes to invite written submissions from the public as part of this review. Any comments, questions, motions, suggestions? MLA Rosewell.
I'd like to move that the Select Special Conflict of Interest Act Review Committee invite written submissions from identified stakeholders and the public as part of the committee's review of the Conflict of Interest Act, with submission deadlines by 4:30 p.m. on April 8th, 2024.
Any discussion on the item? Not seeing it on the board. You guys are fast. Seeing none or hearing none for discussion, I am prepared to call the question. So those all in favor of the motion, please say aye. Opposed? Online, all those in favor, please say aye.
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 Opposed? Hearing none, and on the famous line from Mr. Speaker, I believe the ayes have it, so that motion is carried and passed. The committee wishes to seek public submissions so as a common practice to engage services, legislative assembly, corporate communications in developing a communications plan to encourage responses from the public. I'd like to call upon Ms. Christina Steenbergen. If I messed that up, I apologize in advance, ma'am. From the LAO Communications to advance the advertising options available. Thank you. And please say your name right so I get it right the next time.
Sure, it's Steenbergen.
Steenbergen, awesome.
Yes.
Got it.
Thank you, Mr. Chair. So we do have several options for promoting the invitation for written submissions. We would obviously recommend the no-cost option first, which would include driving people to the website to to put in their recommendation or their submissions. On top of that, we would leverage our social media accounts. So that would be LinkedIn, Facebook, Twitter, X, and Instagram. That again, just driving people to the website. We could do a media release, which will help get the word out. And again, just get people to submit their submissions. The other options that we do have available are e-cards that we can give the members to send out to their constituencies. And in addition, if there are newsletters in your constituencies that you would like to not advertise in, but put in some wording, we can help with that as well. Those are the no-cost options. That will be no cost, obviously, to the committee. We do have other options if the committee so desires.
Sure, and our clerk would like to add a comment as well.
Thank you, Chair. Just also to advise that normal practice for something like this is to establish a web form or place a web form on the committee's website, so for ease of making written submissions. So, thank you.
Perfect. So having heard that, thank you, Ms. Steenbergen. He bugged me. He said I was going to mess it up, and I had it nailed in my mind, and then I heard him heckling again. So Ms. Steenbergen and also Ms. Roth, so thank you for that. Any questions, comments? There we go. Mr. Ellingson, I got that one right, I hope.
And that's awesome. No T, and you got it. So my question is, obviously all members, including the members of this committee, can promote through our own social media, our own e-newsletters coming from our constituency offices to drive to the website, as you were saying, the no-cost option.
If I may, Mr. Chair. Absolutely. We will prepare some formal graphics from the LAO that you can either repost or submit however you wish. So if there is something specific that we don't have, we can create it for you. But absolutely.
Thank you.
Any other questions? Excellent. Thank you very much, Ms. Steenbergen. Possible motion to create for the communications plan. Oh, MLA Rosewell, you're a frequent flyer today.
Yeah. I'd like to move that as part of the committee's review of the Conflict of Interest Act, the Select Special Conflict of Interest Act Review Committee, A, direct the Legislative Assembly to prepare a draft no-cost communication plan and news release to invite submissions, and B, authorize the chair to approve the plan after it has been distributed to the committee members for their review.
And that was for the public submissions, just to clarify. Just take a look at the wording on the board. I think I may have missed that. I have one bad ear and the other one doesn't work so well.
It's right behind you as well, Gareth, if that's...
Yeah, no, I can see it there.
I think it's item A.
Where's the public there? Direct the Legislative Assembly to prepare a draft no-cost communication plan. Public submissions, yes.
Okay, perfect.
Yep.
So, having heard that, any discussion with the motion? Yes, MLA Ellingson.
Just going on the assumption that stakeholders who are on the list will receive direct communication. And do we want to provide a timeline here? So if all submissions are due April 8th, do we want to say that this draft communication plan would be drafted by a certain date to ensure that we still have time to get those public submissions?
Yep, I would open that up for discussion if there's any other items. Possible amendment could come forward on that, or open it up for conversation. And Christina, I'm being whispered in my left ear that you may want to comment on that.
Yes,
so over
thank
to
you, Mr. Chair. If the deadline for the submissions is April 8th, I would recommend having all of these options ready and available by minimum March 8th, so that there would be a month, if the committee is okay with that. We would also send out the media release on the 8th, just providing as much notice as possible.
So I would put it back for discussion here. If the member wants to amend his motion, that would be amiable, or if somebody from the floor would like to amend the motion, then we can go through that process as well. For clarity, if required,
Sure.
MLA.
I'm comfortable with March the 8th as the date that that communication goes out. So we could amend that, prepare in Part A, direct the Legislative Assembly after prepare a draft no-cost commissions plan and news release to invite public submissions for approval and distribution no later than March 8th. And
Sorry, talking to the
Just give us a moment here.
Yep.
Well, thanks for your patience on this, folks. So we get it at the table here. So MLA Ellingson, if you want to read that into the record for us.
Move that the motion be amended in paragraph A by adding by March 8th, 2024 after invite public submissions.
Now, we can go for discussion. Any discussion on the matter? Okay, I'll call the question on the amendment to the motion to be added. All those in favor, please say aye. Aye. Any opposed? Online?
Aye.
Aye.
Any opposed? Hearing none, motion carried. Okay, now we're back to the main motion, which has been amended. And any further discussion on the amended motion? And we'll just throw it up on the screen for everybody to make sure we've got an amended, or the amendment that was carried in there to the motion. I'm curious to ask how MLA Hunter's lunch is going. I'm getting a little peckish myself right now, quite honestly. One of the advantages of working online. So seeing the motion as amended, MLA Rosewell, you want to have a look at that, see if that makes sense? And Ellingson, you're good too? All right. Any further discussion? No? Prepared to call the question. All those in favor, please say aye.
Aye.
Any opposed? Online, please say aye.
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 Any opposed? Hearing none, motion carried. Awesome. And I'm just looking at my notes to make sure we're at which one here. So committee members now proceeded to direct seeking written submissions, common practice, direct the Legislative Assembly office to prepare a summary of the submissions received. I'd like to open the floor for comments, questions, concerns on this matter. And if anyone has any motions. MLA Rosewell.
I'd like to move that the Select Special Conflict of Interest Act Review Committee direct the Legislative Assembly office to prepare a summary of the written submissions received by the committee in relation to its review of the Conflict of Interest Act.
Excellent. Having heard you read it and see it on the board, any discussion to this motion? MLA Arcan Paul.
Sorry, just clarifying question. We will get full copies of the written submissions, correct? Not just the summaries?
Yep, that's correct.
Thank you.
And they'll be posted on the internal website. Any other items for discussion, questions? I am prepared to call the question. All those in favor of this motion, please say aye. Aye. Any opposed? Online, please say aye.
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 Opposed? Hearing none, this motion as well is approved. Next steps in the review. So honorable members, in the coming weeks, it's anticipated that the 24-25 budget will be considered by the Assembly and Legislative Policy Committees in accordance with Standing Order 59.0111. The committee will be unable to meet from this period, starting with the consideration of the main estimates by the Legislative Policy Committees until final vote on the main estimates and the written submissions are in the House for the committee's supply. The committee will continue to receive written submissions from stakeholders and the public through this period until April 8th, 2024. The next steps in our review after receiving the written submissions will be to review those submissions and determine whether the committee wishes to seek additional information on the Act by hearing oral presentations from stakeholders or members of the public. Are there any questions or comments, concerns regarding the review? Hearing none. We'll move on to the next item of business. Other business. Are there any other issues for discussion at today's meeting? Seeing none, next item is item 6. Next meeting will be at the discretion of the chair, and obviously it'll be after we get through all the other committee meetings we're going to be involved with, reviewing estimates. If there's no other items, I am prepared to ask if someone was committed to adjourn this fun meeting we've had today. We've got numbers of hands going up. I'll take MLA Long. MLA Long has read quite loudly a motion to adjourn the meeting. Any discussions? All in favor? Opposed? Excellent. Thank you so much for everyone's participation and your humor getting through this today as well. And we'll see you at the next one. Thanks. Take care.
Aye.
Is that severe?